commented on Mr. Rittenhouse's right to remain silent. The first time he was admonished by the court, the second time the court had the jury leave and re-admonished him on that. Prior to Mr. Rittenhouse testifying, this court addressed various things with not only Mr. Rittenhouse, but with the lawyers. You had cited various statutes, and then you had asked if anything would be coming up on, for example, I think 90608. One of the other things you addressed was 90404. And you had said that based on the information that had come out at the trial, nothing had changed as it relates to your ruling. Shortly thereafter, Mr. Binger stated, and we looked it up, previously, he said to Mr. Rittenhouse, previously indicated that you wish to have your AR-15 to protect someone's property. Clearly in violation not only of the prior ruling that you had made, but the ruling that very day, that very morning. It appears to be that there are two really elements the court must consider when making a determination on a mistrial for what amounts to prosecutorial overreaching. And the first one is the prosecutor's actions must be intentional in the sense of a culpable state of mind in the nature of awareness that his activity would be prejudicial to the defendant. I would argue to you that that's clearly aware of that. You had warned him, you had told him prior to Mr. Rittenhouse testifying that these things, certainly the 90404 was off limits. You had warned him about the infringement on his constitutional right to remain silent. He did it again. The second one, I think, requires some action by the court in terms of a finding. The second one says the prosecutor's actions was designed to allow another chance to convict. That is, to provoke a mistrial in order to get another kick at the cat because the first trial is going badly, or to prejudice the defendant's rights to successfully complete the criminal confrontation at the first trial. Now, the case that I had cited is a Kenosha case, State versus Coping.
Opening?
Yep. 100 with second, 700.
Copening?
Yes, sir. In that case, the court didn't make findings regarding the prosecutor's actions. So I don't know that it's my role to sit here and say who's winning. I don't think that's necessarily what I'm supposed to do. But I think the court has to make some findings as it relates to the bad faith on the part of the prosecution. And if the court makes a finding that the actions that I had talked about were done in bad faith, then I think both elements for mistrial with prejudice have been met. And I think under the circumstances, based on what I've put forth on the record, I would certainly ask the court to consider those. And I would ask the court grant the motion with prejudice. Thank you.
Thank you. State?
Your Honor, I would like an opportunity to more fully respond to this with a little bit of research. At first blush, though, and I reserve the right to present case law and additional cites to the court, but I do want to point out for the record that the defendant has presented interviews to at least one media source and at least one online source since his arrest. And there have been questions about that night. There have been questions